When Congress passed the Americans with Disabilities Act of 1990, which you've probably heard of as the ADA, their goal was, and I quote, to assure equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. My name is Joe Gibson, and I'm a Maryland disability discrimination lawyer. I'm proud to help further the goals of the ADA by holding Maryland employers who violate the ADA accountable. Let's talk about it. The ADA isn't the only law that prohibits disability discrimination, but it's an important one, so let's get into the details. First, the ADA doesn't apply to every employer, only employers with at least 15 employees. There are state and local laws that may cover smaller employers, but we'll talk about that in a minute. The ADA, as you would imagine, protects people with disabilities. But what exactly is a disability? The ADA defines disability in three main categories: an individual with a physical or mental impairment that substantially limits a major life activity, an individual with a record of such an impairment, or an individual who is regarded as having such an impairment. In other words, you can qualify for the ADA's protections by having a disability, having a history of a disability, or by being considered by others to have a disability, even if you don't. Now, the ADA doesn't just prohibit discrimination and harassment. It also requires that your employer make reasonable accommodations that would allow you to perform your job duties. This could take the form of assistive devices, a schedule change, or even a shift from full-time to part-time employment. However, an employer is not required to provide accommodations that constitute an undue burden by way of the accommodation's expense or difficulty in implementing. As a Maryland disability discrimination lawyer, I can tell you that much of my work involves an employee that asks for a reasonable accommodation and their employer who says the request isn't reasonable. Now, I mentioned other laws that prohibit disability discrimination in Maryland. Maryland has a state law called Title 20, which also prohibits discrimination and harassment based on disability. But Title 20 also doesn't apply to the smallest of employers. Several Maryland counties, however, do have their own disability discrimination laws on the books, some of which do apply to employers with less than 15 employees. There's a couple of things you should know about suing for disability discrimination under the ADA or Title 20. First, you can't go straight to court. You or your lawyer will need to file an administrative complaint of age discrimination with a government agency first. That's generally the U.S. Equal Employment Opportunity Commission, the EEOC, or the Maryland Commission on Civil Rights, the MCCR. The acronym you file with depends on whether you plan to sue under the federal law, the ADEA, or Maryland state law, Title 20. If you're filing with the EEOC, you need to file your administrative complaint within 300 days of the discrimination. This is called a statute of limitations. And if you wait more than 300 days, you may not be able to bring your case at all. If you're filing with the MCCR, you only have 180 days, or 6 months, to file an administrative complaint. If you're facing disability discrimination in the workplace, you should talk to a lawyer as soon as possible. Here at the Employment Law Center, we offer a free, confidential consultation, and we can generally make that happen the same day you reach out to us. You can contact us on our website at www.elcmd.org or on the phone at 240-384-5705. Here at the Employment Law Center of Maryland, we sue bad bosses.